Hello, this is Robert Mansour, and we're going to spend a few minutes learning about the estate planning questionnaire. I'm going to try to offer you some guidance as you make your way through the questionnaire. And so basically you'd go to my website and click on Get Started and download the questionnaire. This one is for married couples. So let's take a look. The first thing you should notice is the beginning here. It talks about all of the important things that you should keep in mind. Remember to be accurate, provide the best information you can, and don't worry if you can't fill out the whole thing. A lot of times clients have a difficult time coming up with some of this information, so it's quite all right. Just do your very best. The first section is called personal information right here. And you're going to write the date, how you learned about my office. Here you want to write your full legal name. Now this is the way your name is going to appear in the documents. So you want to pick, a name that's not too long, not too short. If you have a middle name, you might want to just put a middle initial, because you will be signing this way all your documents. So if your name is, really long, that might be a real difficult thing to sign all your documents that way. Include your birth date. Social security number is not terribly important. Include your spouse's information as well as your full address, your phone number, etc., so that we can reach you. Also, it's nice to include your email address, because sometimes we may need to contact you via email, and only if you check it regularly. Otherwise, it's really of no use. One of the reasons I want to find out is if you're widowed here. We want to find out if there was a spouse and when that spouse passed away. Also, if you were divorced, we need to find out whether or not there's anything about that divorce that will affect what we are doing now. Need to find out if you're a U.S. citizen. There are certain trust provisions that are applicable to non-citizens, so we need to find that out. One of the reasons I want to find out if you own more than one home is we need to find out how many parcels of real estate we're going to be putting in the name of the trust. Here we ask you how much your house is worth and how much you owe on it, because we want to figure out if there's any estate tax issues. And one of the issues that we talk about is the net versus the gross. Here we ask if you have any prior estate planning documents on the bottom, because I need to review those before the meeting. On page 2, you'd write down all the children that you have from your present marriage and their dates of birth, etc. Later on in the page, you might want to include children from prior marriages, and which one of you is the natural or adoptive parent of these particular children. On page 3, we ask if you have any deceased children, only because we want to find out whether or not these kids have any children of their own. We don't want to miss any grandchildren. Also, we want to find out if your children are in good health, which might affect whether or not they receive a distribution. If any of the children are disabled, that may also affect whether or not they should be receiving a distribution. Sometimes you might want to disinherit somebody who would otherwise receive from you. We can indicate that in the documents as well. Later on in the form right here, we ask if any of the kids are receiving SSI or government benefits. The reason for that is because if they are, or if they might receive government benefits, they might lose those benefits if they inherit from you, and we need to think of some protective provisions about that. Sometimes family members have trouble with drug addiction, alcoholism, trouble handling money, etc. We want to make sure we include provisions in your estate plan that protect against that. Then I ask whether or not stepchildren should be included in your estate plan. The reason for that is you may have kids who are not your natural children. Or one of your children or more of your children is married to somebody who has children from a previous relationship. We have to ask ourselves, will they be included in your estate plan? The next question asks whether or not one of your children were to die before you, would you want that child's children to receive the distribution? In other words, would you want the distribution to go to the grandkids? So this is something you fill out even if you don't currently have grandchildren, because we want to create a plan that will last many, many years and not just the immediate future. So essentially, let's say you have 2 kids and one of your kids were to pass away. Will that child's 50% pass on to the next generation? In other words, your grandchildren. You want your children to get their distributions right away or not? Sometimes you have grown kids with good heads on their shoulders and you have absolutely no concerns. Go ahead and let them have their distributions right away. Sometimes we have kids who are younger, or perhaps they're not terrific at handling money, in which case we might want to give their distributions to them in stages. And one of the most common ways to do that is by age. So here in this particular section of the form, you would indicate that. And you could choose from a variety of different schemes. Sometimes some people like to include a college incentive clause in case they want to encourage their children to go to school, like a college, and we have to define what that is. And also, if the grandchildren should be subject to the same restrictions as your kids. So let's say your kids are going to receive their distributions at age 25, 30, and 35. Should it be the same for your grandchildren? And we can talk about different ideas regarding that. Here we indicate whether or not, if you have children from previous relationships, you and your spouse, do you consider them all to be your children, even if they are from prior relationships? Some people entered the picture when the kids were very young and they consider those kids to be their own. Here we talk about whether or not there's going to be anybody else that will receive a percentage of your estate, somebody other than your children. So for example, 10% to my sister Katie, or 20% to my church, or whatever. You don't have to fill this out, but in case you have anybody else in mind, that's what you'd put there. That's section C. Section D is other intentions regarding your estate. So do you want to treat your children equally? If not, please explain why. Also, if one of you were to pass away first, are there going to be any outright gifts at that time? Sometimes clients have certain family heirlooms or want to make sure that one of the children is taken care of upon the first death. That would be common if there was stepkids or children from previous relationships, etc. And we should discuss that, but I will tell you most commonly there are no gifts upon the first death. At the end of page 4 is the apocalypse section. Basically, if all of your named beneficiaries were to pass away before you, in other words, all your kids and all your grandkids and nobody else, what would you want to happen to your estate at that time? Most people pick one or more charities, or our siblings in equal shares, etc. You can come up with whatever is best for you, and we can certainly discuss that. On page 5 is where you choose your trustee. Your trustee is going to be in charge of your trust. So basically everything in the name of your trust will be managed by this individual. Typically, of course, you will be first in line for each other. After that, you want to choose successor trustees. So right here on this part of the form, on page 5 of the questionnaire, this is where you would indicate your successor trustees in the order that you want them to serve. Sometimes people say, well, what about co-trustees? I'm not a big fan of that, and sometimes that can lead to more trouble than it solves. Page 6 is where you choose the executor of your will. This is the person who would go to court and handle a probate if it was necessary. That's section F. And it's very common to choose the very same people that you've chosen as your trustees. Moving right along, in section G is where you'd list any guardians for your minor children. So if you have minor kids under the age of 18, which is the current law in California, you'd want to name them in order who is going to take care of your kids. And we can certainly talk about that. Section H is your Advanced Healthcare Directive section. This is the person called your agent who is going to make healthcare decisions for you and basically be your advocate. Of course, husband and wife are in line for each other, and then other people are after that. Now, typically, I do make the healthcare directive effective immediately, which means that no one needs to declare you incapacitated first, which is very helpful because you might need somebody to be your advocate right away. So let's say they're not paying attention to you in the hospital, or they're not helping you and providing you with the right medication. Your agent can go ahead and advocate for you right away without having you declared incompetent, so long as your healthcare directive is effective immediately. The next section here is called Location of Care at the bottom of page 7. This is where some people sometimes have a specific desire to be cared for at home. They don't want to go to a facility. Others just leave it up to their agent. On page 8, I ask you whether or not number 1 or number 2 apply to you. Now, number 1 is where you basically want as much health care as possible to keep you alive, all measures possible. Section 2 essentially states, I don't want any extraordinary measures just to keep me alive. It's more a quality of life issue than a quantity of life issue. Number 3 here is whether or not you want nutrition, hydration, medication, or treatment for the alleviation of pain or discomfort. That basically means that there might be times when having those things will prolong your life, but that's not the main reason that your agent is giving it to you. They are giving it to you to relieve your pain or discomfort. And that will sometimes help when there is a challenge. And somebody might say, hey, why are you giving them nutrition or hydration? All you're doing is making them live longer. And then here you would indicate whether or not you have any preference, cremation, burial, etc. Keep in mind you can just leave that up to your agent as well. On page 9 is where you would indicate your agent under power of attorney. This person can basically act on your behalf for everything that has nothing to do with the trust. Remember, your trustee handles trust matters, but your agent under power of attorney can basically step in your shoes and represent you in many other situations. Again, husband and wife are first in line for each other, followed by hopefully 2 people at least, maybe more if you wish. Now also with this document, I generally make it effective immediately as well. And the reason for that is because you may want people to act on your behalf without them having to jump through any hoops. They don't have to get you declared incapacitated or incompetent or anything like that by any doctors. But some people do prefer to have that hurdle, so we can discuss that during our meeting. Then there are some miscellaneous matters that you might want to check out on the subsequent pages. And then, right here on page 11, or excuse me, page 10, you would want to circle all the important reasons that you're doing estate planning so that when I'm helping you plan, I make sure that I keep your goals in mind. And then we get into section K, which is essentially the financial summary part, where you would list all your real estate, all bank and credit union accounts, any life insurance accounts, annuities. I do ask for approximate values because that helps me when it comes time to estate tax recommendations, and if there are any. Retirement accounts such as 401ks, pension plans, IRAs, very common things that people have. And then the next section is on page 12. I ask for any securities you might have, some brokerage accounts, investment accounts, etc. And then finally, going on here, if you have any business interests, maybe one or more of the husband or the wife has a business that they have. If you have any boats or automobiles, you might want to list their value here, as well as any kind of artwork or significant items of value that you might have. Some people have a lot of jewelry, baseball card collection, antiques, basically anything worth several $1,000s. Also, promissory notes if anyone owes you any money, possible future inheritance, any prior legal agreements that I need to be involved in or take a look at that might affect what we're doing, any U.S. savings bonds, etc. And then some information on the final page that helps me, such as learning more about your CPA, your financial advisor. I may have to work with these people when it comes to putting together your plan and making sure that your assets are titled properly. So anyway, that is the estate planning questionnaire for married couples. The same basically applies to single people, except that there's no spouse involved. It's just for one person. So this is very helpful for clients to fill out in advance of our meeting and makes our meeting much more productive. I hope you enjoyed it. Of course, we will cover all of these things during our initial consultation. Again, this is Robert Mansour, and thank you for visiting my website.